down the list, you'll get to the most, as we get down the list, we'll get to the most restrictive, which is the guardian and the conservator. This is the one that we want to avoid unless it is absolutely necessary, because it is the most restrictive for the individuals. So I will talk about powers of attorneys, financial and healthcare, and Ms. Tina will talk about guardianships and conservatorships. Again, we are based in DC, and so where it is specific to DC, we will mention that, but each state has their own rules for guardianships, for powers of attorneys, and et cetera. Okay, so the first tool that I want to talk about is the financial power of attorney. So what is a financial power of attorney? It empowers the principal, which is the person who's making it. So for the social workers, it'd be your clients, to appoint a trusted person who we call their agent to handle their finances. It's because it says financial, people think it's only about money, but it's more. It's pretty much everything except healthcare decisions. And when we say healthcare decisions, we're literally talking about whether or not a person gets surgery, what kind of medications they take. A financial power of attorney, on the other hand, is the one who's going to be able to pay for rent, to pay other bills, to pay hospital bills, all of those things. It's important that you know whether or not a power of attorney is durable. Durable is a term that means it survives incompetency or incapacity. The actual term will depend on the state and how they view the rules, but essentially, a durable power of attorney is a power of attorney that says that this agent, according to the rules I put in this paperwork, can act on my behalf even if I become incapacitated in the future. So why do people make powers of attorneys? The main reason is to avoid guardianship, because guardianship is extremely restrictive. In DC and in many other places, the person who's incapacitated does not get to choose who the guardian is. That is somebody that is appointed by the court. So the court may appoint somebody that they don't know or that they don't like. The other reason to make a power of attorney is because it provides assistance. And by assistance, I mean, this agent can do a lot of things. My clients are homebound, they can't go to the bank. A power of attorney will allow somebody to go to the bank for them, will allow somebody to talk to the landlord when they're in the hospital, to get to move things out of their apartment if they decide to let go of their apartment. The other reason is that you can make it as very specific as you want. You can have it very broad or you can have it very limited. And you choose the person who would be your agent. So for example, you can have a general power of attorney, which oversees all of a person's life. This is often what we do for our older clients who are starting to, maybe have memory issues and they need somebody to be able to oversee everything. Or you can have a very limited power of attorney. So my father travels a lot. He has a limited power of attorney, granting my mom permission to do whatever she needs to do with the house. That's the only power she has. She can remortgage the house if it's necessary, because don't want to wait for him to come back for that. That's a very limited power of attorney. One thing about a financial power of attorney is when a person is making it, they get to decide what it says. And so like I mentioned, it can be very general, meaning everything that a financial power of attorney has the right to do, they can do, or very limited. It can also change when it becomes effective. It can be effective right away. So as soon as the paperwork is signed, the agent is able to take that paperwork and go to the bank and start doing things. Or it can be springing, meaning that it takes effect after a triggering event. Usually when two doctors say that the individual lacks capacity to make decisions for themselves. This is the wraparound, or this is the way you avoid guardianship. You've already decided this is the person who's going to take care of me if something happens to my capacity. I've already made that decision. So there's no need to go through the guardianship process, which actually requires you to go through court. And Ms. Tina will talk about all of that later on. Some key things about a financial power of attorney. It is only effective while a person is alive. Once the person passes away, there are no more financial decisions to be done. The will takes over, so it's a good idea to make sure that there's a will as well. And once it's made, it can always be changed or canceled. The individual who made it is the one who can change it or cancel it. The financial power of attorney must be in writing. This is very important. A lot of people think that just by saying this is my financial attorney, this is enough. It isn't. It really needs to be in writing. And the reason is you can't control what people say, but when it's in writing and it's notarized, in DC, it's required that it be notarized. I saw a lot of people from Maryland. In Maryland, it is not only required to be notarized, it also must be witnessed. Other states, you can check the rules. Usually, Attorney General page has some information about it, given how important this document is. It's important that it's in writing. And if you are working with people who say, oh, I'm somebody's financial power of attorney, to ask for the paperwork. Because without that paperwork, you don't actually know if they have the authority to act. And you don't want to get in trouble for acting without having that authority. So when somebody makes a power of attorney, they do not release any rights to make decisions for themselves. They keep a lot of rights for themselves. Like I mentioned, they can change it, they can cancel it. They have a right to an accounting. They have a right to know what the agent is actually doing. They have a right to be kept informed of all decisions, right? It pertains to their lives. They're acting on the agent is acting on their behalf, just the same as an employee acts on the behalf of an employer. And the individual keeps the right to make decisions for themselves. Just because you have a power of attorney doesn't mean that you can't sell your home on your own if you wanted to. You don't have to go through your agent. Now, if an individual loses capacity, that's a different question. One thing that I must mention is a power of attorney is a state-created document. There is no federal equivalent. So federal government does not accept powers of attorneys. So if you're going to be trying to help somebody, or if you yourself want somebody to help you with your Social Security, your federal retirement benefits, or your VA benefits, you have to go through that agency's process. It's either a representative payee or a fiduciary. That's how they manage to avoid the whole guardianship system. So financial power of attorney allows somebody to make decisions for you. However, you can still make decisions for yourself as long as you have the capacity to. It has to be in writing, and you set the terms of what your agent can and cannot do yourself. All right. I am going to move on to the healthcare power of attorney. Okay, the healthcare power of attorney is very similar to the financial power of attorney. The healthcare power of attorney, however, is limited to healthcare decisions only. This is very important because each state will have different rules about this. But essentially, your healthcare power of attorney is the one that if something happens to you and you cannot communicate with the doctors, and when we say communicate, I mean the doctors will really try to get you to communicate because it's a lot better if they hear it from you than somebody else. So you're not able to communicate with the doctors, or you no longer have capacity to communicate effectively with the doctors. Then the person you appoint, this trusted person, is the one who's going to be making the decisions. In DC, the healthcare power of attorney is only effective in those circumstances, right? If in other states, and this is why it's important to check with your states, the power of attorney can be effective, the healthcare power of attorney can be effective immediately. And the same rules apply in the sense that it's only effective when you're alive. Once you pass, there's no more healthcare decisions to make. That the individual can make a change or revoke, cancel out the power of attorney. They have to do it in writing. The healthcare power of attorney also is required to be in writing. it pretty much in all states, they require the presence of 2 witnesses. Who those 2 witnesses can be depends on the state. So the best option is witnesses who are not related and who are not working for or affiliated with the hospital of the individual. This is because this is the person who's making a decision about whether an individual is living or dying, what kind of treatments they're going to receive. So you want to make sure the witnesses have no interest in the outcome of the decision. A lot of people do not know what they want their end of life to be, and that's fine. But I think everybody really should think about making a healthcare power of attorney, because as we saw with the pandemic, things happen. And if, for example, you never bothered to get divorced, then that spouse who you're estranged from will be the one who makes a healthcare decision, because every state has substitute healthcare decision maker who can step in case you're not able to vocalize your needs. And that's the person who's going to be deciding whether or not to give you, whether or not you go to surgery, whether to just let you go, if you have not already written out your end of life plans. So very quickly, because this is less to do about the health, the power of attorney, but individuals can also make advanced directives, sometimes called a living will. These are specific instructions for medical treatments for when you're unable to communicate your wishes. The benefit of this is that you can list down what you want at the end of your life, what you would like your end of life time to be. For example, if you're in a coma, doctors say you're not going to wake up. Do you want them to just let you go? Some people have very strong opinions about it. Some people do not have very strong opinions about it. One thing to remember is that as attorneys, we are not doctors. We will always recommend people speak with their doctors to know what the best option is, because medicine changes and the law is very slow. Medicine changes much faster than the law. There is also, in DC, it's called the medical orders for scope of treatment. I think in Maryland, it's medical orders for life-sustaining treatment. Different states have different names. Not all states have this, but it's a form you sign with your doctor that's registered with the Department of Health that actually outlines what you would like your end of life treatment to be. Sometimes they combine it with the do not resuscitate orders. So in DC, they did away with the do not resuscitate orders, and it's now part of this form. This is a useful form for people because at least in DC, you can attach the healthcare power of attorney and it will be registered with the Department of Health. So every hospital is supposed to be able to pull that directly from the database if they're in DC, and be able to get that information without having to wait for somebody to track down the agent or find out whether or not there actually is a power of attorney for healthcare. So this is very useful, particularly in emergency situations. So quick recap, healthcare power of attorney, it's about medical decisions only. Different states have different rules, but in every state, it has to be in writing. You get to appoint the person that you trust. While you have capacity, like with the financial, you can still make decisions for yourself. In different states, the power of attorney may be effective right away if you choose so. In some states, it's only springing, meaning that it's only when you're no longer able to communicate with your doctors. You can attach instructions as well to your power of attorney through the advanced directive or living will, or you can just make an advanced directive or living will if you cannot identify somebody. Okay, so that's a recap of financial powers of attorneys and healthcare powers of attorneys. We're going relatively fast, partly because we want to have time to answer your questions, and partly because these are very complicated documents and we could literally talk about them all day. And I don't think you want to sit here listening to us speak legalese for like 8 hours. So, all right, I'm going to pass it on to Tina, who will speak about guardianship.
Thank you, Catherine. If you all remember one of the slides that Catherine began her presentation with, she showed you all a continuum from the least restrictive measures to the most restrictive measures. And so on that continuum, the guardianship and conservatorship is the most restrictive measurement. That's what we try not to get to with our clients. But we obviously recognize that sometimes clients get to the point where, because of their capacity issues or cognitive issues, they are not able to make decisions about their person, their finances, or their care. And unfortunately, those particular clients may not have had the opportunity or taken advantage of the opportunity to prepare a financial or healthcare power of attorney that Catherine just explained. And so for a person who has not had the opportunity to appoint an agent through a power of attorney to make those decisions for them, if again, the person becomes incapacitated in the future and someone needs to step in to make those decisions for that person, that's when a guardianship or conservatorship have to be put in place. To go through this process, you have to actually go through a court process. So whereas a power of attorney, you can make that decision on your own in consultation with an attorney as to who you want to appoint, what powers you want to bestow upon them. When we get to the point where a guardianship or conservatorship is needed, we have to go through a legal proceeding with a court, and a court will make that decision. The court will make a decision either to appoint a guardian because someone has petitioned to become the guardian. It could be a family member, it could be a close friend. And then sometimes, depending upon the situation, if there's no one available, then organizations, government entities like APS can request that the court have someone appointed as the guardian. But if there is someone identified, then a petition is filed with the court. The court collects documents, medical documents, to determine or to ascertain what the extent of the person's incapacity is, and how much they're able to assist in their own care and to make decisions on their own. And so if a person is identified to serve in that capacity, again, that person would petition the court to become someone's guardian or conservator. If no one is identified, or if for some reason the person who has petitioned to the court to become the guardian or the conservator, but the court finds for various reasons that they are not the person to be appointed in that position, then the court will appoint someone else to serve in that capacity. And so in the District of Columbia, we have a fiduciary panel where there are attorneys in the district who have decided that they are willing to be appointed as a person's guardian or conservator. And so the court would select someone from the list to serve in that capacity. If you're in another jurisdiction, it could be set up differently as to how people are appointed by the court to serve in that capacity. But I just wanted to stress that the person can either someone can petition to be a person's guardian or conservator. Again, you're typically a family member, or if not, then a third person can be appointed by the court. And in some jurisdictions, the guardian is the person who makes decisions over the person themselves, like where they live, what type of treatment they receive, do they need to go into a long-term care facilities? Those types of decisions are regarding the person themselves. And then there's another function, which is the conservatorship. And that person is basically responsible for making financial decisions. In some places like the District of Columbia, those are two separate positions. So you can have someone appointed as a guardian, and you can have someone appointed as a conservator. It could be the same person, or it could be different people. In some jurisdictions, the guardian and conservatorship role is combined into one person. And so one person is responsible then for making decisions on the person's regarding the person's body, and also making decisions regarding their finances as well. So you need to look to your jurisdiction to determine whether or not these are two separate functions, or whether these functions are combined in one person in your state. Just as Catherine advised about the powers of attorney, guardianships and conservatorships can also be general and can be limited in time and scope as well. So you can have a guardian appointed for specific reasons and to handle specific issues or specific matters as determined by the court. Or you can have a general guardianship or conservator, and that person is responsible for every aspect of the ward's life. So it's important that if you run into a situation where you are assisting a client that has a conservatorship or a guardianship, that you get a copy of the order from the court, because the order from the court will specifically lay out exactly what the responsibility of the conservator or the guardianship is and what the limits are. So again, as Catherine advised, don't take a verbal communication as gospel. You want to make sure that you get that document yourself so you can review it, so that you can know that whatever decisions the person is making in their capacity as guardian or conservator is in line with what the court has ordered. Next slide, please. Okay, so why do we need to seek guardianship and conservator? Again, as I explained previously, this happens in the case where a person does not have a power of attorney in existence in which they have already appointed an agent to serve as their power of attorney agent. Now, we do have a provision within the powers of attorney that we prepare at LCE, whereas if for some reason the power of attorney fails to meet the legal standard, then there's a provision that says, if for some reason this power of attorney fails, then I would want this person appointed as the guardian for me. So again, the person that is appointed as guardianship is appointed because the person who is having capacity issues is unable to make decisions regarding their personal well-being, their finances, and their health. And at this point, they don't have the ability to prepare a power of attorney, because in order to prepare a power of attorney, you have to have legal capacity to prepare a power of attorney. And it doesn't mean that you have to understand all the legalese. It just simply means you need to understand, in terms of power of attorney, this is the person that I want to appoint to handle these matters for me. But when you get to the point where you're unable to appoint that person because the law recognizes that you no longer have the legal capacity to understand what you're doing and to contract, then you cannot make a power of attorney. And the person who is giving over that authority would be the person making the power of attorney. Often we get clients, children or spouses who call us to say, I want to get power of attorney over my mom or my child or my grandchild, but you can't get power of attorney over someone. The power lies within them, the person who's giving you that authority. And so when we get to the point where we are seeking guardianship or conservatorship, that person no longer has a legal capacity to make that decision, and therefore guardian has to be put in place. And as Catherine said, and as we showed on the continuum, again, this is the most restrictive. And so while the person still has capacity, we try to emphasize the importance of getting these documents prepared, because then you can appoint the person that you want to serve in that capacity, and it's not a stranger or a third party that the court has appointed that is making these decisions for you, but you have made the decision on your own to appoint someone that you trust, that you know of, to make these decisions for you if you are to become incapacitated in the future. Next slide, please. So what can a guardian conservator do? Even though a person is under a guardianship or conservator, as to the extent possible, the person who is appointed as the guardian or conservator should try and have a conversation with that person. In DC, they're called the ward. They could have a different name in your jurisdiction, but in DC, the person is called the ward. So as much as possible, the guardian or the conservator should have a conversation with the ward to determine what decisions the ward wants to make about their personal well-being or their financial well-being. Obviously, if the person is incapacitated to the point where they are not able to engage in that conversation or bring any meaningful information to that conversation, then the guardian and the conservator will be making that decision on their own. But as much as possible, the guardian and conservator should include the ward in those decisions. And again, it's the same powers that the person would have given over had they prepared a power of attorney are the same powers that a guardian now obtains or has in making decisions about their personal care decisions and the financial decisions. Next slide. So what are the rights under guardianship and conservator? Just because a person is under a guardianship or conservatorship doesn't mean that they lose all of their rights. Again, as I expressed, to the extent possible, the guardian or conservator should have conversations and involve their ward in conversations about the care and the treatment they want and what they want done with their finances. But even under those circumstances, the person who is the ward of the state does not lose all the rights. The person has a right to be treated with respect and dignity, to be free from being abused or exploited or neglected. And what's most important about it is if for some reason the person who's appointed, who is subject to the guardianship or conservatorship, wants or needs to make a change in the person who has appointed, maybe that person that was appointed is not really making decisions in their best interest, or they're making decisions that are not financially sound, then the person who is under the guardianship or conservatorship can go back to the court and request that someone else be appointed to serve in that capacity. So that is a right that the person has. The person also has a right to file a complaint with the court. Again, if for some reason the person who's appointed as the guardian or conservator is acting outside of their scope as identified in the court order, then they can go back to court and they can file a complaint against the conservator or the guardianship for not abiding by the court order. And they also have a right in DC, the guardian and the conservator are paid. If the ward has enough financial resources, then the guardian and the conservator are paid out of the ward's resources. But if not, there's a fund in DC that is set aside where the appointed guardian or conservator can apply to get paid. But assuming that the person appointed as guardian conservator is being paid from the resources of the ward has a right to contest it if they think that the attorney's fees that the guardian or conservator is charging them, again, money that's coming from their estate, is too high. They have the right to contest that fee or that compensation with the court. And so those are just some of the rights that even if you're under a guardianship or conservatorship, that you still maintain as a member of society. Next slide. Unless Catherine has something you want to add.
Oh, some of these are DC specific. So the right to the mandatory review every 3 years is something that was passed within DC. And the process can change, like in DC, they're very good about the individual having the right to an attorney and ensuring that the attorney, that the person who's going to be placed in the guardianship is present at the hearing, which is why we're continuing to do the hearings online. But the judge will ask why the individual is not in the courtroom if they're not there. I think that some of you may have seen the movie that came out, can't remember the name, where somebody was placed under guardianship.
Britney Spears.
No, not that one, even though that one does provide you with a lot of examples as to why guardianships, yes, I care a lot. I have a hard time reconciling that name with what happened in the movie. So I have a blockage with the name because she did not care a lot. But yes, in I Care a Lot, you'll see like some of the things, the negative aspects of guardianship and conservatorship, and then why it's so important for there to be some sort of review to it.
Okay. All right. Issues with guardianship and conservatorship. Again, on our continuum, the guardianship conservatorship is the most restrictive option. So obviously, we want to have the least restrictive option available for all of our clients as well. So that would include, a supportive decision-making, powers of attorney, and then moving up the continuum. Because the guardianship is is the most restrictive, we want to use it as sparingly as possible, because there are a lot of personal autonomy and decision-making that the person who is subject to the guardianship or conservatorship gives up or loses when a court has appointed someone to make those decisions for them. Again, because of the way in which the process works, at least in DC, the person who's appointed as the guardian or the conservator may not even be a family member. And so from the ward's perspective, you have a stranger making very personal decisions about your body and your care and your finances that you don't even know. And so, you know, there's a trust issue that's there as well. And then with regards to the conservatorship, sometimes we run into issues with financial institutions such as banks, and they put up barriers for guardians to be able to access funds or move around funds or withdraw funds. They don't have a problem with you depositing them, but when you want to withdraw them, then it becomes an issue. So, you know, these are issues where we try to avoid by, again, having the client prepare as much as possible the powers of attorney so that we don't get to the point where they no longer have capacity and no one has been appointed to handle their business, personal, financial affairs. And so there has to be legal court involvement. And with DC, with the guardianship, there are reports that have to be submitted to the court. In DC, it's every 6 months. So it's a lot of responsibility as well for the person who has been appointed as the guardian or conservator. Again, I would tell you to look to your jurisdiction to see what those processes are. But in any case, there will always be court oversight over the guardianship and conservatorship. And so there will be reports and other things that the guardian and conservator must provide to the court in order to keep the guardianship alive. And if the guardian and conservator fail to do that, then they can be removed and another person would be appointed as well. Next slide. That might be the last slide. That is the last slide. So that is a really broad overview of powers of attorney and guardianships and conservatorships. You know, I saw that there were many questions in the chat. I'm not sure how we're going to handle that. I think Robin was looking at those and maybe we can answer as many of those as possible in the time that we have remaining.
Yes, so Tina and Catherine, thank you so much for that presentation. That was a lot. But it was super interesting. So in no particular order, I've been trying to jot down questions as people have been answering them, but I'm just going to rattle off a few and I'll see what I've missed here. Someone asked, can veterans with memory issues appoint a POA?
Yes. When you're dealing with somebody with memory issues, it's really important to work with an attorney. The attorney can analyze to see whether the person is just having memory issues and their answers are consistent, and therefore their point of view are consistent. They just may not remember meeting the attorney. That's fine. I've worked with clients who are like that. But there is a certain time where if the individual really has no idea what you're talking about every single time you sit down and talk, it may not be appropriate at that time. So yes, they can. They definitely can make powers of attorneys, but it'll depend on the continuum, how far gone they are. And if it's a veteran, they may also want to make sure that they get a VA healthcare power of attorney form, and as well as, you know, if it's required a fiduciary through the VA, and that's a separate process.
Thank you. Another question, are guardianships honored across states?
Yes, but it's a little, oh, go ahead.
Yes, guardianships are documents that in our legalese are entitled to full effect across jurisdictions. As long as the guardianship was prepared in the jurisdiction and meets that jurisdiction's legal requirements, then another state should recognize the guardianship that was prepared in another state.
So you really have to know what each state's legal requirements are, correct?
And that's why you need to go to an attorney to prepare these documents. One of the things that we often see is people like to go to like LegalZoom.com, or they might want to go to the internet and pull off a document, and they were like, "Oh, I have a power of attorney drafted," or "I have, some other legal document." And what I always advise is that's a good place to start, because it gives a person a general idea of the provisions that are included in these documents. But you really do need to see an attorney in the jurisdiction where you live, because there are specific requirements that each jurisdiction has in order for that document to have legal effect. So it could be that it has to be notarized. It could be that it requires one witness. It could be required that it requires two witnesses. So there are very specific requirements for each jurisdiction. And so if a document is prepared but doesn't meet the legal sufficiency of that jurisdiction, then it's as if the document was not created at all. So in order for a document to be considered valid in another state, it has to be certain that in the state where that document was created, that document meets all of those legal requirements. And if that is the case, then again, another state should recognize it.
And to add, if you are planning to move a ward to a different state, there may be additional work that you have to do with the court in terms of transferring that, if they're going to be living long-term in another state, so that the new state is the one that is overseeing the guardianship or conservatorship. And again, that's like each jurisdiction has a different way of going about it.
Got it. Thank you for that. Someone asked what SDM is, and I don't remember from your presentation.
We didn't talk about it much, but it's a supported decision-making agreement, or supported decision-making, which is simply, it's something that everybody does. Whenever we have to make a decision, we get help from other people, but this is formalizing that relationship, so that, for example, somebody, with an intellectual disability who may have a hard time understanding doctors, there's somebody who's required to be there with them at their doctor's appointment, who can talk to the doctors, explain information, but the individual with the disability is the one who makes the final decision. So it's very, it's formalizing that agreement so that others understand that this other individual can stay in the meeting, can get access to their information, etc.
And I will add to that not every jurisdiction has supportive decision-making. DC, I believe around 2013, don't quote me on that, but put in a provision within their laws that allowed for the supportive decision-making documents to have legal effect. So you would need to check with your jurisdiction to see whether or not your state even recognizes supportive decision-making tools.
Got it. Question, how often should the guardian in DC see the ward?
Once a month is the requirement. However, I'm not quite sure if they're requiring guardians to do it in person yet. That was, the in-person part was put on hold during
COVID. I
COVID.
think they are back to, I think the DC courts are back to requiring that the person appointed as a guardian or conservator actually sees a person in person. But as Catherine said, during the pandemic, virtual visits were allowed.
Does a guardian also make financial decisions?
It depends. Like I said, in some jurisdictions, the role of the conservator and guardianship are integrated into one person. And so, I mean, if you think of it that way, then am I wearing my guardianship hat and making this decision, or am I wearing my conservator hat? But all the decisions are being made by individual persons. But in DC, they are actually two distinct functions. You have a guardian, you have a conservator. And so the conservator would be the only one responsible for making financial decisions, unless it's the resources of the ward are very low. For instance, if their only income is SSI, then the guardian in DC can be given permission by the court to, make sure that payments are coming in, or if the payments are not coming in, then they have the authority to, file for a fair hearing with the Social Security Administration, or to follow up as to why those payments have not been received. So there's like a little baseline, limited responsibility that a guardian can have in DC in handling financial matters as well.
Good, thank you. This is sort of a comment, but someone mentioned that many doctors in DC and Maryland do not seem to know about the medical orders for scope of treatment, or the MOST form, or they don't initiate discussions with their patients. Can you speak to that? Maybe, why does that happen, or how someone can make sure that that is happening?
It's, at least in DC, it's relatively new, and there hasn't been a public push for it. I don't know why. I think it's really a great idea. I also think part of it is when you're going to your doctor's appointments, the doctors are focused on whatever issue you have, and then they're moving on to the next. So they don't necessarily spend a lot of time on it unless you bring it up. I have downloaded the form for DC to provide to my clients so that they make an appointment with their doctors specifically about that. So that it, and again, most of my clients are on Medicaid, so it's they're able to make those appointments without as much concern about medical costs and whatnot. But it's unfortunate. It's just something that needs to be really pushed. I know I believe in nursing homes in Maryland, like they're pretty much required to do that, and to propose that, if not actually do them. And in DC, there has been a huge push in the rehabs as well for them to turn to talking about that. Somebody mentioned the 5 wishes.
Yeah.
The 5 wishes is the advanced directives and the living wills. It's a company that put it together and called it 5 wishes, but that's basically what it is. It's
Got it.
pretty much how your wishes for end-of-life treatment officially is called advanced directive or living will. Don't really like the term living will because people confuse it with the last will and testament, which is only after you pass away.
Got it. Someone asked if the original power of attorney document is not available, is a copy sufficient?
Depends on the institution. Banks are going to want to see that it's notarized if a notary is required. Most other places will accept a copy.
Yeah, most places should accept a copy. You do not have to have an original signature, but that also says some jurisdictions have what's called the uniform power of attorney, which means that any power of attorney that is prepared by a person, a third party has to recognize, like a bank. We don't yet have that in DC. And so in DC, you could have a financial institution that even though you have a valid financial power of attorney, the financial institution may require that you have their own specific financial power of attorney in order to access the accounts of the person giving over that responsibility. DC is actually on the very, very edge of getting the UPOAA. It has been approved by and signed by the mayor. And so it's making its way through Congress for approval, but we do anticipate that in 2023, DC will be another jurisdiction that recognizes the UPOAA, which will then get rid of third-party financial institutions requiring their own power of attorney documents.
Okay.
And I do want to mention Maryland got in a lot of trouble, or banks in Maryland got in a lot of trouble when Maryland did the UPOAA. So I have actually told my clients, take your powers of attorneys to a branch in Maryland to see if it will work, because the Maryland branch may be more receptive and understand that, they'll have to jump through a lot more hurdles. Each state has different rules. And so you have to check the states to know whether or not banks, it's usually the banks, it's really financial institutions who have issues with it. Most other places are like, That's fine.
Understood. Someone asks, can a power of attorney transfer that authority to someone else?
So for financial, no, because of what the implications are. So if you are unable to be, when we work with our clients, what we ask is for them to name a representative, their one agent, and then a backup in case that first agent cannot. That's usually good enough protections, especially since we're working with older clients who usually pick their children. And so, you know, that's usually good enough.
Mhm.
However, if something were to happen to both of those children and they lose capacity, or if both of those children step out, the individual has to have the capacity to make a new power of attorney, or it would be onto a guardianship. You can't transfer a financial power of attorney. Now, with a healthcare power of attorney, you can, if the power of attorney itself says that the agent can choose somebody else, but we don't recommend that. Again, we recommend having backups because you want it to be very clear. And the last thing anybody wants is for there to be debates among family members, because if the healthcare power of attorney is rejected for whatever reason, and these, you know, if they're not accepted, or if there's conflicts or whatever, it can go to court and the judge will decide, and it'll be like, and the judge doesn't have to decide that it's either people who are fighting. They can decide that it's somebody from the fiduciary panel here in DC. They don't have to stick with the rules. So the clearer adding backups prevents any of these issues from coming up.
And you can have more than one backup. You can have
Yeah,
a secondary person if the first backup doesn't work out.
yeah.
I'm going to combine these two as our last questions because it is 3 o'clock and I want to be mindful of everyone's time. So one was, what cognitive capacity must an individual have to grant power of attorney? And then kind of along those same lines, how can one become a representative payee if the individual is not able to appoint?
Well, in terms of the first question, again, the person does not have to have enough capacity like to understand all the legalese. People with full capacity can't understand all legalese. Sometimes I don't understand all the legalese, but they have to be able to understand, at least like for financial power of attorney, enough to know this is what I own. You know, this is who I want to take care and make decisions for me. This is a person that I know and I trust. And this sometimes this person has already been doing these things anyway. And so we're just going to formalize it and legalize it and put it in a power of attorney document. So it doesn't require that the person really understands all of what goes into creating a power of attorney. Just simply understand that this is the person that I know, that I trust to make decisions for me, because for whatever reason, I don't want to make those decisions now, or I want that person, or I trust and believe that person will make the best decisions for me when I become incapacitated. So it's really a low level of understanding that's required. But again, they have to be able to understand, this is what I own financially. This is the person that I want to handle those decisions for me. And, you know, this is the person that I trust and I want to appoint.
For the representative payees, you have to apply directly with either Social Security Administration or OPM. They have their own vetting process. If the individual is incapacitated and cannot make that appointment, Social Security takes that into account and they have their own process. There are forms they do. They may require a doctor's note or other information, but Social Security, OPM, VA, they all have that. If you have a guardianship or a conservatorship, then it's a little bit of a more streamlined process because presumably the court has already done the vetting. I do want to add one thing is that I think this was asked in the beginning, we are a DC organization and we are only in DC. We help low-income individuals, and that's 200% of the federal poverty level. However, we do have reduced fee and regular fee attorneys that we have vetted. So if individuals are interested in getting services in DC and they are DC residents, they can contact our services. Now, well, I should say this, a lot of states have this kind of service. It may not necessarily be in a organization that deals specifically with the elderly, but I do know that Maryland has an organization that tries to help people with wills and such, and usually wills and powers of attorneys are all done together because it's planning the end of your life.
Great, thank you. This was a great presentation, and obviously everybody had lots of questions, and I think you answered a lot and provided some great information. So thank you both so much for sharing your expertise with us today. For everyone that attended, just a couple of reminders. I am going to stop the recording in just a moment. The program was recorded. It will be included in the post-event email that will be coming from Key to Cross. She will also have a survey in there. Please complete that survey if you'd like to get your continuing education credit for this program. Please check out our website, which I did put in the chat, smithlightcommunities.org, for our future programs. We have one more coming up tomorrow, and then called The Perks of Coffee, which will talking about some health benefits that you may not realize from coffee. And then we will start planning for 2023. You'll see our programs on there. So thank you all very much for attending. And I hope that you